Well, good morning to you, and thank you for those very kind words, Representative King. I appreciate that introduction. It is good to be at ALEC. I was an ALEC member many, many years ago. I was kind of sharing and kidding with some of my colleagues as I was coming in from Oklahoma. When I gathered at ALEC back in the late 1990s and into the 2000s, I would come to these conferences and we would talk about all these grand ideas and things that we needed to do to reform education and public safety and all these various issues, and go back to Oklahoma and not be able to pass one of them. And so for you to be able to come to this place and talk about great ideas and then go back to transform your states, you're doing good work. And I really appreciate what ALEC means in advancing policy across this country. I really appreciate what you do as a legislator to advance policy at your state and to exercise the discretion and authority and power that you have at the state level. And having been in the legislature, I understand that well. And it's something I want to talk to you about today with respect to the issues that we're facing as states and as attorneys general. It's good to be in Texas, the Republic of Texas, to some, the state of Texas, of others. My good friend General Abbott, I know, is going to spend some time with you later in the week. You know, I love coming to Texas for many reasons, but the most important time is in the month of October. There's a little event that occurs not too far from here called OU Texas. South of the Red River, it's called Texas versus OU, but we call it OU Texas in Oklahoma. And I'm just so thankful I got invited to come this year with ALEC being hosted in Texas, because you know, if we'd have beat Texas like we have in the past, like we did 2 years ago, I may not have gotten invited. But we didn't do so well last year. But it's good to be here, and my daughter, actually, we come and watch the football game and enjoy the football game most years. But my daughter is actually an Oklahoma Sooner. She's a cheerleader at OU, and so we come and watch that as well and watch her perform. I heard all these stories. I see Speaker Howell. Speaker Howell and I actually co-chaired the Civil Justice Task Force with my good friend Victor Schwartz for many years here at ALEC, and I didn't get a chance to talk to Speaker Howell about my kiddos and how old they are now and where they are in their life. But she's at Oklahoma cheering, and we watch her, and I heard all these stories when kids go away that they don't stay in touch. They don't write, they don't phone, they don't text, and McKenna has stayed in touch because she needs money. But I heard this story as she went off to school that caused me some concern about a young lady who had gone off and didn't stay in touch, didn't write, didn't text, didn't call, and it was nearing the end of the year. And she sent a little note to her daddy and said, "Dear Dad, everything is good here. The dorm did burn down, and I did lose all my personal effects, but I found a new place off campus to live with a new roommate, Jim. And Jim's doing really well. He's been in recovery for almost 6 months now. And I know that we've not been in touch, and I've not stayed in touch, and I fully understand why you didn't make it to the wedding, but I know you're not going to miss the impending birth of your new grandchild." She signs it and then says, "P.S. Dad, everything above is untrue. I did flunk chemistry. I just wanted you to keep things in perspective." Well, let me say to you, we have to keep things in perspective as attorneys general across this country right now, because we are facing, as the representative said, I think a key time. You know, there are certain times, certain seasons of time that as you're living them, you know that you're affecting and impacting history. We know those from the past, and at the inception of this country, if you read the letters that were sent from the founding generation to each other, they recognized that they were living in a very, very important and strategic time. They were marking time. And we've known those throughout our history at different points. Obviously, World War II was one of those times. You know, we just celebrated our 70th anniversary of D-Day this year, June 6th of this year. And I went back and read the speech that President Reagan gave June 6th in 1984, 40 years after the D-Day invasion. He was at Pointe du Hoc, and he gave a presentation there, and he talked about the importance of what those men did on D-Day. Listen to this quote by President Reagan. "These are the men who took the cliffs. These are the champions who helped free a continent. These are the heroes who helped end a war." I mean, they knew that they were living in a very important time. They were marking time. They acted with courage. They obviously demonstrated commitment. They were unwavering and persevering in the cause throughout that war. If you go read that speech, by the way, it's so palpable. As you read the words of President Reagan, he told the story about how those boys charged the beaches and then went to Point Hawk, and as they started climbing those cliffs, sheer cliffs, there were gunners at the top just taking them down one by one, and as one fell, they would just keep climbing over and over until they reached the top and took the hill and took the cliff. Courage and commitment, and obviously very consequential. They not only just won a war, they impacted the trajectory of freedom in history into the future. Now, if I ask you a question today, as you gather here today, as you talk about policy, as you talk about education and public safety, as you talk about health care and all the things that you deal with as a state legislator, if I ask you rhetorically, obviously a question, and said, do you believe that we are in a similar time, what would you say? Would you believe that, in fact, we are living in the midst, in some estimations, in the midst of a constitutional crisis? You know, I was in Washington, D.C. last year, and I was speaking to a group of attorneys and judges with the Heritage Foundation, and I posed that question, and I really didn't know how they would respond. I mean, sometimes you just kind of throw those things out, and you wonder, is it going to be received, and how it's going to be received? And I asked that question rhetorically to that group of judges and attorneys at the Heritage Foundation. Do you believe that we're living in the midst of a constitutional crisis? I was astounded by the response. They responded much like you. Yes. Now why do I say to you that I believe, perhaps, that we are living in a time where literally the trajectory of our nation is at risk and at stake as we respond to what's going on in Washington, D.C. There has been ebb and flow between the federal government and the states over time about what role that we're to play and how much authority the state exercises and how much authority the federal government exercises. That's been ebb and flow throughout our history. But why is this time different? How is this time different? And that's what I'm going to talk to you about today, because I believe what's at stake today is not just the normal debate and discussion about, cooperative federalism and how states work with the federal government and how we jointly serve our citizens and make the difference that we all seek to make. I think what's at issue today is truly rule of law. I think what is at issue today truly is something that puts us on a path toward dangerous waters if we don't change the trajectory that we're on. After all, look at the attitude that permeates Washington, D.C. today. I'm going to talk to you about a couple of EPA cases that we're involved in a second, but I want you to know my comments are not limited to one agency of the federal government. They're not limited just to the EPA. Our Affordable Care Act challenge that the representative made reference to is a case that's fundamentally about rule of law, about the IRS disregarding the plain, unambiguous language out of the Affordable Care Act that said states have a decision about the healthcare exchanges, that states, once they make that decision, there are certain consequences to those decisions. And the consequences of those decisions is that no subsidies flow in those states that choose not to set up an exchange. And if there are no subsidies, there are no penalties. That's what the law says in Section 1311. That when 34 states across this country said to the federal government, with all the incentives of money, billions of dollars, that they were not going to set up healthcare exchanges, what was the response of the federal government? The response of the federal government through the actions of the IRS was simply, we'll fix that. We'll just simply change the law and issue a rule that says this is what we're going to do. Now, irrespective of what your opinion is about the Affordable Care Act, irrespective of what your opinion is about whether it's good policy or bad policy, and I'm on the record for saying that it's bad policy, which I'm sure many of you are as well, but irrespective of your opinion, we all ought to care about an agency of the federal government who acts after the fact to change statutes as passed by Congress and signed by the President. That is wrong, and we ought to care about it. But this attitude of saying that we want to improve upon a statute or fix a statute is where our focus is as state attorneys general across this country. We are responding almost in a defensive posture to the challenges that we see. And I want to visit with you about a couple of cases in the energy/environment context that I think matter. Some of you have lived this very personally. Some of you know these matters more so than others. But when you look at this approach that's being taken in the energy context, it is so frustrating. In the great state of Oklahoma, we have seen a renaissance, as Texas has and North Dakota has and others, at accessing energy that we could not touch 20 years ago. You know, and my friend General DeWine in Ohio and others in other parts of the country, they really don't know what hydraulic fracturing is. And I've spent some time with them and let them know that that's really not a new process. Hydraulic fracturing has been going on for decades. We've been regulated in the state of Oklahoma for decades. We have a robust regulatory agency and environment that deals with that. What is new is the ability to drill down 2 miles and go left or right 2 miles and access natural gas and oil that we couldn't in the past. But we involve that fracking process to make sure that we extract that natural gas and oil as we drill horizontally. We are living in the midst of a great renaissance. We are truly energy independent today. We just are not going after the energy that we have. We should be exporting natural gas, and we should be exporting oil, and we should be doing all those things. The capital is there, the infrastructure is there, the know-how, the expertise, and more importantly, the resources are. Why should we be dependent upon others to turn on our lights and heat our homes? It makes no sense whatsoever. There's only one thing standing in the way with respect to us seeing a tremendous change across this country and manufacturing revitalized, and that's the government. The barriers that are placed upon the states and industry in developing the resources we have. I made reference to this a week or so ago. I was on a panel with the EPA General Counsel in Park City, Utah last week, and I don't watch MSNBC too much, but when I do, I watch Chris Hayes, apparently. And so on this show, he had the president giving an interview, I think it was to Mr. Krugman, about energy policy in this country. And I was shocked by what was reported. The administration in this show talked about that the goal of our energy policy should be to keep 2/3 of the fossil fuels in the ground. That's the goal. And so when you have that stated as clearly as that, you start asking the question, this body called the EPA, this agency called the EPA, what is their role? What is their objective? Is it to pick winners and losers in the energy context? Is it to say that renewables are good and fossil fuels are bad, and so we're going to use our regulatory power to penalize fossil fuels, to elevate other types of energy? You know this, but if you look across this country and look at how fossil fuels power electricity, if you combine oil, natural gas, and coal together, it approaches 70% of what we use to generate electricity. If fossil fuels go away, if we don't go after 2/3 of our fossil fuel that is in the ground, I ask you a question. What's going to happen to the cost of electricity? What's going to happen to manufacturing in our businesses? I'll tell you what's going to happen. Costs are going to skyrocket, and we're already seeing it. There's a couple cases I'm going to illustrate for you to demonstrate that, but costs are going to skyrocket. And I've often wondered, how can you have leaders in the federal government that understand that but still push it anyway? And here's what I think. I don't think they're terribly concerned about the cost rising. Jimmy Carter talked about conservation in a voluntary way. This administration, this EPA, and all the agencies associated with it, they're trying to make electricity so costly that they're forcing conservation for you to use less across this country or pay an exorbitant price. That's what this country's facing in the years ahead. How do I know that? Well, by a couple cases that we've been involved in. One was the Regional Hayes case. Under the Clean Air Act, again, getting to rule of law and federalism, under the Clean Air Act, the Regional Hayes rule, or the statute, is not a safety and health statute. It is about aesthetics and visibility. The Wichita Mountains in Oklahoma. We as a state were responsible for implementing and adopting a plan to improve visibility in the Wichita Mountains. We did that in 2010 as a state. A previous governor, Governor Henry, a previous leader of the Department of Environmental Quality, various stakeholders across the state did their job to adopt a plan to reach the goals as identified under the Clean Air Act for Regional Hayes. In fact, we beat the deadline by more than 2 decades. The goal was 2064, that we would reach natural visibility in the Wichita Mountains. The state's plan reached that more than 2 decades before, never disputed. Submitted the plan in 2010. But guess what happened within the first 3 months of my tenure as Attorney General? The EPA administrator came into the state of Oklahoma and said, we don't like your plan because you're keeping fossil fuels, particularly coal, in the mix. And we're going to reject your plan, and we're going to force upon the state of Oklahoma a federal implementation plan that at that time was going to cost the state of Oklahoma, through our utility companies, OG&E and PSO, over $2 billion within a 3-year period, causing utility rates to go up almost 20% within 3 years and annually thereafter. Now, when I say to you that the goal is to make it so cost prohibitive that electricity is used less, that's an example. And it's an example of the federal government coming in through the EPA, disregarding the plain statutory authority and responsibility of the state of Oklahoma and every state in the country. North Dakota, Colorado, other states were affected, and despite that limitation upon the EPA, they chose to act anyway. That's demonstrative of picking winners and losers. That's demonstrative of an EPA exerting itself in a way to penalize the role of states that are clearly defined in the statute under the Clean Air Act. That's why it matters what you do. You know, Oklahoma was not recalcitrant. Oklahoma was not negligent. It was not unresponsive to its responsibility. It acted. It made decisions. But despite that, this EPA didn't like the decision that was made and sought to displace it. And that's what we're facing. I mentioned hydraulic fracturing to you earlier in my comments. Do you know under the Clean Water Act that the EPA has no jurisdictional authority over hydraulic fracturing unless the frac fluid that's used in the extraction process has diesel in it? But despite that, frac focus is something that industry publishes their the fluids that they use, and if there's no diesel, EPA has no authority. But despite that, what is the EPA doing today? They're engaged in a study to do just what I mentioned, regulate and overtake the regulation of hydraulic fracturing at the state level, either displace it or duplicate it, to make it so time-consuming that it affects production across this country. That's picking winners and losers. I know many of you, and you're going to talk about this, beyond the regional haze case, an example of the EPA exceeding its authority, we have on the horizon, I think, something even more troubling. And that's the proposed rule under 111D with respect to CO2 regulation. We have an EPA that is engaged in rulemaking, proposed rulemaking now, that seeks to exert itself in a way that the statute doesn't authorize at all. You know, Mass v. EPA, the case from 2007, stood for the proposition that CO2, the EPA had authority and jurisdiction to regulate CO2 with non-stationary sources. That's what the case stands for. That's the holding of the case. And so now EPA has extended that to say we can do stationary sources, but when you look at that issue, there's nothing in the statute that tells them how. And so why is that? Because CO2 was not an air pollutant under the Clean Air Act until the U.S. Supreme Court said that it was. And so now they're trying to find the way to do that, and they're looking at all these different options, and really it's very difficult for them to find that option, so they're just kind of creating it, in my estimation, out of thin air. And so what they did with this proposed rule, and something that we're very concerned about from a state level perspective, is they've come in and said we're going to have a cap and trade without the trade approach to how we regulate CO2 with stationary sources. Instead of regulating on a facility-by-facility basis inside the fence, as it's called, like the Clean Air Act proposes and establishes, the EPA recently came out and said, we're just going to do a mass emissions reduction across the state, and you go figure it out, industry, in those states across the country. The only problem with that is that's not what the statute says. But that's the approach that the EPA is taking. Again, another example of the EPA taking a statute and saying we'll improve or fix or take a different approach that has not been authorized by Congress. One of the other areas that I'll mention to you that I think is equally troubling, and it's something you probably have heard about and you're going to talk about this week if you haven't already, and that's this phenomena called sue and settle. Now, I don't know about you, but when I was in the private sector, you attorneys in the room, when I got sued or my company got sued, I normally didn't walk in the same day that the lawsuit was filed and raise the white flag and say, you got me, and enter into a consent decree. I didn't do that. We evaluated the case and we determined if there was exposure, and we looked at our defenses and we took the responsible steps of defending our client. But we have examples across the country where there are many instances where the EPA has been sued, where a consent decree has been used to do things that, in my estimation, are completely inconsistent with what a consent decree should be about. Let me say this to you. A consent decree, a settlement, is a proper thing in and of itself. It's a proper vehicle to resolve a lawsuit. There's nothing inherently wrong in a consent decree. That's a settlement between two parties that's entered before a judge for enforcement purposes. But when you enter into a consent decree as an agency to engage in rulemaking or to amend or alter a statute, that's wrong. That's regulation through litigation. And that's what's happening with sue and settle. One example that I'll share with you this morning, a case out of Tulsa, Oklahoma. It's a beautiful place. It's where I live. Tulsa, Oklahoma, we have a case in the Northern District of Oklahoma, and we have two other states that have joined us in that, along with Farm Bureau and an association, the Domestic Energy Producers Alliance. They've joined us in that case against the Fish and Wildlife Service in the utilization of the Endangered Species Act in a wrong fashion, a consent decree. Under the Endangered Species Act, the statute, and again that should matter, the statute says there are three buckets, three categories. As the Fish and Wildlife Service looks at listings for threatened and endangered, there are three choices. One is warranted. They should be listed as threatened or endangered or not warranted, and that's self-descriptive, obviously. The third category is warranted but precluded, statutorily created. That third category is something called a study category. And what has happened historically is that when the agency cannot make a determination, they want to engage in evaluation and testing and evaluation, they put the species in that third category and said, we'll spend time evaluating that and studying it. And what generally happens when species are listed in that third category, states go out and spend money to avoid listings in the first bucket, the warranted bucket. And they'll go out and adopt voluntary conservation plans and whatnot. Well, guess what happened recently? The Fish and Wildlife Service got sued. They got sued by Wild Earth Guardians, and as the lawsuit was initiated, they started negotiating, I trust, with Wild Earth Guardians, and as they discussed the lawsuit with that plaintiff, they made a decision to do something that they didn't have the authority to do. They eliminated the third category. They took 251 species in the third category and said, we're just going to take that category out, and we're going to make a decision in a truncated timeline on all 251 species by no later than September of 2016. And the first one that was listed was the lesser prairie chicken, which affected hundreds of thousands of acres in a 5-state region, farming and ranching and oil and gas. And they did so not because they were required. They did so not because the law said that they had to do it. They did so because of a consent decree with a nonprofit organization called Wild Earth Guardians that wanted them to act that way. And they did it. That's what's wrong about sue and settle and consent decrees being used. And so we, as a state, didn't step back and say, well, what do we do about that? We sued. We sued the Fish and Wildlife Service. And we said that your consent decree is not consistent with the statute. And that was rulemaking, and you amended the statute, and we're going to hold you accountable. And North Dakota and Kansas have joined us in that, along with these other associations, and it is my hope that the courts will send a strong message to the Fish and Wildlife Service to say that you cannot engage in that type of practice. You can do consent decrees, but you cannot do what? Do rulemaking or amend or alter a statute through that process. That message needs to be sent because the EPA and other agencies are on the path of doing that across this country. It is wrong, sue and settle is wrong, and I appreciate your attention to that matter, and we hope that the courts respond. I'm encouraged. I'm encouraged that at the end of this last term with the U.S. Supreme Court, I think we're at the beginnings of a message being sent to the executive branch. If you look at some of the decisions that came out at the end of the term, the NLRB case that dealt with the recess appointment issue, the EPA case, another EPA case where the EPA is authorized by statute to regulate power plants of 250 megawatts or more. The EPA tried to say, well, we're going to go below 250 megawatts, and we're actually going to do what? Regulate it at the church, school, and business level. It's called the Tailoring Rule. We joined with Texas. Texas sued the EPA, and guess what the Supreme Court said at the end of the term? EPA, you're wrong. You can't do what you're trying to do. That's a good message. The NLRB case was a good message. I believe that the Hobby Lobby case was a good message to the executive branch to say, you're exceeding your authority. You're exceeding your authority under the Constitution and statute. So I am encouraged that the courts are starting to recognize that they must speak to this breakdown between the branches and the executive branch exerting too much authority. It's an important time. It's an important time for you as a legislator. It's an important time for this country. I mentioned at the beginning the courage, the commitment, and the consequential time that the boys of Point to Hawk lived within and the accomplishments that they had. And I wanted to encourage you today that we're living in a similar time. We must respond. This is not your normal tension or ebb and flow between the federal and state government. Rule of law is at risk. There's a phrase, lex rex. The law is above the king. And I'm so thankful to have lived in a country where that phrase and rule of law was something that was stable and we could count on. But I will say to you, I think that we've taken that for granted. I think we have taken for granted that the structures, the checks and balances, the rule of law, federalism at its core, vertical checks and balances, that would just be bequeathed from generation to generation. Sure, policies may change, administrations may change, but the structures that we know surely will not be affected, and they will pass from generation to generation. I'm here today to say to you, don't take that for granted. It is being debated today in ways that I never would have guessed, with executive orders being issued that say, though the law says one thing, we're simply not going to do that. We're going to do this. We have the Attorney General of the United States of this country spending time saying that the law can be disregarded and they can choose not to prosecute or to enforce the law because they have that preference to do so. We cannot take for granted that these structures that we hold dear are going to pass from generation to generation. The question is, what are we going to do about it? For my part, I can tell you that we're going to continue the path that we're on. We're going to use the powers of the state of Oklahoma, the Office of Attorney General, and the courts to hopefully gather accountability, whether the issue is health care, finance with Dodd-Frank, or in the area of energy. And I pray that as you do your job, as you go about your business, that you will look at the authority that you have as members of your respective legislative bodies and say, how do we maintain a commitment to rule of law and the responsibilities vested in us and achieve accountability? Teddy Roosevelt one time said, in any given situation, the best thing you can do is the right thing. The next best thing you can do is the wrong thing. The worst thing you can do is nothing. You're doing something. Keep it up. And let's make sure that we do exhibit courage, that we maintain a commitment to rule of law and persevere in this battle that we're in, because I will say to you, and I believe this with all my heart, it is consequential to your children and future generations to make sure that they live within the structures that we know provide freedom and liberty for the long term. Thank you very much for the time this morning.